Okay, we will begin our next panel. We're about 5 minutes late, but I think we're okay. We'll be okay. This first panel in the morning after our keynote address is titled "The Future Shape of Energy Reform in Mexico." Having understood where Mexico is at this point in energy production and what the intentions of the government are in attracting new investment, know-how, and technology that the Mexican government does not have, then we want to now discuss what is it that we can expect in terms of a reform in Mexico, the extent, the depth of that reform, and the scope of what the Mexican legislative bodies, the Senate and the lower house, are expected to pass, given the negotiations between the presidency and the PRI party and the two other parties in Congress, the PAN and the PRD. So what is it that we can expect? Where are the limits of this energy reform expected in Mexico by the end of the year are going to be? I have at the table first here George Baker. George, welcome. George is the longtime editor of Mexico Energy Intelligence, a Houston-based newsletter that addresses matters of commerce, institutional development, law, and regulation. George also directs Energia.com, where visitors may read interviews with stakeholders and analysts and read reports on topics of interest. George holds a PhD in history from Duke University and an MA in the social sciences from California State College, Fullerton. We also have at the table Javier Antonio de la Garza, who graduated with a law degree from the UNAM, the National University in Mexico. He holds an LLM from the University of Houston. Welcome back.
Thank you.
De la Garza specializes in financial affairs and business law in connection with the oil and gas industry. He has been working with Pemex Exploration, Production, and Petrochemicals for the last 23 years and has been an advisor to Pemex's office in Houston. He currently works for the Legal Affairs Office in Pemex, where he is in charge of litigation, arbitration, and the implementation of Pemex's international agreements. And we also have Alberto de la Peña, who heads the Mexico cross-border practice of Haynes Boone in Dallas. He got his law degree at the Escuela Libre de Derecho in Mexico City in 1994, and he also has an MBA at Southern Methodist University. He is licensed to practice law in Texas, New York, and Mexico. I'm going to ask each of the panelists to make remarks for about 5 to 7 minutes, and then I have a number of questions that we thought were important, and I'm going to throw the questions on the table and allow the panelists to answer, and then we'll open it to a question and answer session. So first, at bat, George. Thank you.
Can you hear me all right? Good.
Get really close, George, so the video can capture your voice.
That's one of the disadvantages of being tall. You have to do this. Anyway, I'm glad to be here. Tony, thank you. Thank you, Erica, thank you to the Baker Institute for including me in the program today. In my 5 to 7 minutes, I'd like to explore 2 topics, and they're both hinted at in this article that's on your table. It's an editorial that was published in Reforma a week ago. How many of you have already read this article? Okay, those of you who haven't, that is your assignment, but not while I'm speaking. So I want to start with a general observation that I've had for perhaps 20 years, and that is that in Mexico, the future of Mexico in matters of energy and the future of Pemex, the future is very clear. What's so terribly confusing is the present moment. So what I want to do in my remarks is to talk about what's going to be clear about the future of Pemex in one respect, and try to clarify what's so terribly confusing about the present moment. So what's clear about the future of Pemex is that it is inevitable that there will be a Pemex 2.0. And Pemex 2.0 will be a mixed capital company that will be majority state-owned, and it will have a minority of common shares in the New York Stock Exchange. And there are reasons for this, reasons why this is inevitable. And the first is that this is a global trend. In Statoil, Petrobras, and a dozen other national oil companies, this is the pattern for the last 20 years. There's no reason that Pemex should be locked into being only a Mexico operator. There's a second reason, and that is, as an agency of the federal government, it cannot operate outside of Mexico, not even in cross-border oil fields. That is, some of you know, there was a treaty signed between the U.S. and Mexico in 2012 that established a framework for the development of cross-border oil fields in U.S. federal waters and Mexican federal waters. Pemex cannot be the unit operator of a unitized field as an agency of the federal government of Mexico, because it would be entering U.S. water as a foreign government. So even at home, there needs to be a Pemex 2.0 to be able to operate flexibly with cross-border oil fields. And then there's a third point, and that is, some of you remember, that have the same color hair as I do, the East Talk 1 oil spill in 1979 and 80. And some of you may know, either by memory or reading about it, that in the litigation that followed, because oil came to the beaches of Texas, the Pemex defense side, and Antonio and Javier, you were not involved in that, so I'm not insinuating that you were part of this, defense. The Pemex defense team said, un momento, sovereign immunity. So Pemex walked away from this liability under this legally valid position. So in the light of the Macondo accident, no international oil company is going to want to have as a strategic partner anyone who could remotely consider or be forced to consider the option of sovereign immunity in case of another Macondo in a joint venture. So that means that Pemex would be blocked, in my view, from having the strategic alliance that was mentioned by the previous speaker to go into the future, which is the kind of alliance that it needs. Let me turn to point 2, how to clarify the present confusion about energy reform. Many of us ask ourselves, what does the government want from energy reform? And why is it proposing constitutional changes? I want everybody to pause at that. Why is the government proposing constitutional changes, and what does it really want? That's a moment of silence for you to think about that. And the answer is that it wants to take the oil regime as such outside the Constitution. That is, it wants to have Article 27 of the Constitution to be limited to talking about oil in situ. That is to say, oil in the ground like any other mineral. And the government wants, rightly, I believe, to have the flexibility to say that it's in the hands of the Congress and it's in the hands of the executive to devise that oil regime that responds to an evolving technology, evolving business models, and evolving market conditions. It's a very reasonable position to clean up the Constitution, which has been mixed up with ideas that have mixed the concept of oil in situ with an extraneous, improper notion of what the oil regime should be to exploit the oil in situ. Is that clear? In other words, we need to separate that out. Oil in situ is one thing. The mechanisms, the terms and conditions, the institutions that exploit the oil in situ, that needs to be outside the Constitution, in the law, in the regulations, and in the institutions. So that's what I think the government's plan has in its mind, and I think that if it accomplishes that, it will be a very big accomplishment. So big that it matters, that that accomplishment will be important, even if, for the rest of the administration, they never issue a single contract to a single oil company. Thanks very much.
Thank you, George. I will now ask Javier.
Sure.
Thank you.
Thank you.
And we do have a PowerPoint, I think. Yeah, it's here.
Yes.
Yeah, thank you.
Thank you. Thank you very much. Good morning to everyone. Thank you, the Baker Institute, the Rice University. Thank you to Heinz and Boone also for this invitation. Besides, well, my profile is a lawyer, so I won't be on graphics, on that kind of stuff that my colleague Froilan goes through, but I will try to make some remarks on what the energy reform expects. The energy reform, talking about the energy presented by the executive, by President Enrique Peña Nieto. So let me talk about that. First of all, the purposes of the energy reform presented by the President of Mexico are to strengthen the role of the Ministry of Energy as head of the sector. What do I mean by this? The Ministry of Energy in the reform presented by President Peña Nieto will allow the ministry to execute contracts instead of Pemex. Right now, with this reform, Pemex will not longer execute the contracts or draft the contracts. Pemex will be another bidder, will be another participant or another player in these activities. Also, this energy reform will allow private investors to participate in upstream and downstream in oil and gas activities. The reform also encourages the modernization of Pemex infrastructure and facilities. This modernization, as Froilan told to you, goes in this way. Right now, Pemex is divided in four entities: Pemex Exploration and Production, Pemex Refining, Pemex Petrochemical, and Pemex Gas. With the reform, the entities that will be comprise the industry will be the infrastructure, the transformation, industrial transformation, and one E&P area. And also there will be a corporate management that will administrate all these entities. Also, the reform will increase the production capabilities and profitability. The reform tries to provide more legal certainty to all participants, and will improve, as my colleague also says, corporate governance regime and autonomy according to best international practices. In the upstream activities, recent deep water and ultra deep water discoveries confirm the existence of vast hydrocarbon reservoirs as well as large reserves of shale gas. So the reform should allow venturers participation in E&P activities through profit-sharing agreements. These kind of agreements are the ones that are proposed in the reform. These profit-sharing agreements should be detailed in the secondary laws to be issued after this constitutional reform be approved. The ownership of the hydrocarbons shall be maintained in the government, in the state. Create considerable oil and gas-related jobs, improve Pemex know-how and skills and expertise, and also Pemex could participate under equal conditions as others in bidding rounds or through joint ventures or alliances. In the downstream sector, private involvement of various degrees in the fields of refining, petrochemical production, transportation and storage, of oil and gas may be attained through permits granted by the government. This will be to improve current infrastructure limitations. For example, in the case of refining, we have, well, in Mexico there are 6 refineries that are very old. So one of the targets with this reform will be to probably construct new refineries or to refurnish the existing ones and try to produce more gasolines or more fuels for the consumption in the country. Also increase the supply of capacity in order to meet domestic demand through upgraded fuels, to overhaul existing facilities and to build new ones according to state-of-the-art technologies, to design successful maquila contracts for the refinement industry to be paid in cash. In this issue, it's also considered in the reform that there will be what we call maquila contracts. Pemex will give the petroleum or the oil to the private persons, and they will refine the products in order to produce gasolines and other byproducts. Also, these activities will permit enhancing and increasing the infrastructure related to transportation and storage of byproducts. These activities must be performed according to domestic and international safety and environmental standards. The challenges of the reform are migrating from one of the most restrictive oil and gas legal framework to a competitive one and a more flexible scheme. Mexico should not exhaust its financial capacity investing in new projects if they can be financed by private capital. Pemex would become more production-focused to be a major player in the industry. The government has the challenge to amend the secondary laws according to the new constitutional regime. The big issue here will be in the secondary laws, because as you know, the constitutional amendments that are proposed are a few ones that Beto will talk about it. And also, but the tax reform proposed by the executive is through a law that it's called Hydrocarbon Revenues Law. This law is a little bit complex. It states a monthly surface rental fee to be paid by Pemex to the government applicable to non-producing contract areas, a production royalty rate that should be calculated and paid by the trust to the government. The trust will be the entity that will receive all the monies from the sales of oil on the gross value of each type of contract, and to Pemex or subsidiaries pursuant to established percentages in each state contract, taking into account the deduction of eligible costs from the contractual value of the hydrocarbons. Right now, this tax proposal states a corporate income tax for Pemex as any other private company, that is currently 30% to be paid by Pemex and its subsidiary entities. So in general terms, this is what the tax reform proposal is, and we're expecting that with this tax reform, Pemex could have more revenues in the projects that we have talked about it. So I think, sorry, but I don't know. The last slide that I have is another issue besides the tax reform. That is, as you must know, Mexico and the United States last year signed an agreement in order to exploit reservoirs in the transboundary in the Gulf of Mexico. The objective of this treaty that has become, well, it hasn't been becoming effective because the Senate has not yet issued, that there is one pending issue case, because I think the SEC wants them to receive the revenues from all the profits in the area of these reservoirs. So once in place this treaty, there will be a good opportunity for US and Mexico to invest in these projects in the border of the limits of Mexico and the Gulf of Mexico. And so we are trying to draft unitization agreements, unit operating agreements, and work together with the the authorities of both countries to try to set up safety and environmental standard rules. So it's my part, and I will receive any questions after for your invitation.
Thank you. Thank you, Javier. Alberto.
Yeah.
Thank you.
Good morning, everyone. So, you know, I'm an attorney, so I want to kind of give the lawyering perspective on the reform. And, you know, this is I have just 5 minutes, but this is the most important reform in Mexican legal system since NAFTA, which happens almost 20 years ago, and one of the most important in Mexico's history. There has been a lot of discussion on you know, whether the reform will allow production sharing contracts, profit sharing contracts, you know, whether the companies will be able to make a booking of the reserves. And all that discussion, I think, gotta be in perspective about, we need to put that in perspective in actual proposal is doing and what can be done with the new reform. In other words, what potential this reform is opening. And to do that, I would like just to briefly review what's the situation now at constitutional level in Mexico. As you know, all the energy sector is pretty much a state monopoly. It was an area that was reserved in NAFTA, where Mexico said, I'm going to negotiate everything except my oil. And there are some areas that have been open to private investment. In '92, a little before NAFTA, some areas in electricity as a self-supply, cogeneration, independent other areas in natural gas, particularly transportation, distribution, and storage of natural gas. But pretty much the sector is just reserved to the state, you know, with Pemex. And this is because of constitutional restriction that George and Javier also mentioned, and it's Article 27 and 28 of our Constitution. Article 28 establishes which are the strategic areas that are reserved to the state. And those include oil and hydrocarbons, basic petrochemicals, and electricity. These 3 areas are reserved to the state. It's a state monopoly by Constitution. And then in Article 27, the Constitution regulates natural resources and the ownership of natural. In that carbon source, as George already mentioned, and it cannot grant concessions or licenses to exploit, and it cannot enter into contracts with third parties. Now, the restriction to enter into contracts that Article 27 mentions has been construed in the underlying legislation as a prohibition to do profit sharing, production sharing contracts, but has allowed services contracts with all the companies that we know. Many of them are present here, and that's why Pemex may have, you know, multiple services contracts, or the last version, the incentivized services contracts, but, you know, cannot give the production or the oil. And in the electricity, Article 27 currently pretty much establishes the same, that the generation, transportation, or transmission of electricity and distribution is reserved to the state as a public servant. Now, what has been proposed in Congress, we have 3 proposals, although there is only really one that is going to stick, and is the one that is being discussed. First, we have, by the end of July, it was the PAN, the right-wing party, submitted to Congress its proposal. It's a constitutional amendment of these 2 articles, and it's pretty much opening to the market the whole sector, giving concessions even for exploration and production. And then, on the other side of the spectrum, you have the PRD proposal, which is the left-wing party, which they want the status quo. They don't want to make a constitutional amendment. They want to keep the reserves and the state monopoly in energy. And they are proposing, in some ways, good amendments to underlying laws to improve the tax regime of Pemex, that is very burdensome, and also to improve the corporate governance. But obviously that reform is good in some ways for Pemex, but it's not enough for the sector. And then in the middle is the President Peña Nieto proposal, which is proposing, in terms of Article 28, deleting from the strategic areas reserved to the state the 3 areas that I mentioned, which is oil and hydrocarbons, electricity, and basic petrochemicals. So once the reform is passed, this will not be, by the Constitution, a monopoly of the state. And then on Article 27, 27 that deals with the ownership of the resources, it establishes that they will be owned as any natural resource by the state originally. The original ownership is by the state, and that, as it is currently stated, there will be no concessions or licenses to exploit. But doesn't say they deleted the restriction that there will be no contracts, and instead it says that the nation will exploit its resources pursuant to the applicable law. So it's leaving to the underlying regulation to state the way the government is going to exploit its own resources. Same as to electricity, it states that the transmission and control of the electrical grid will be controlled by the state, but the state may enter into contract with the private sector based on the terms of the applicable law. So if this reform is passed, which I think it's going to be, what is going to happen is that the only thing that it's doing right now in the legal arena is removing the restriction at constitutional level and leaving to the underlying legislation to kind of structure and shape how the government will partner with the private sector in terms of the exploration, production, and all the other stages in the oil sector. And one important component of this is that it doesn't matter. I mean, you know, even if the underlying legislation probably is not perfect, and probably they don't have the right type of agreements that the market is expecting to, there will always be the possibility to self-correct more easily because they don't have the constitutional restriction. So I think that's something important as we move in this process to understand that from a legal point of view, what the proposal is doing right now is just eliminating a restriction at the constitutional level and leaving the regulation in specific to the legislation. Thank you.
Thank you. I have a couple of questions for the panelists, and then we will open it to a conversation. So some of the questions I had put together have already been answered partially, but I think they're important to go into because they might add some depth to the discussion. So I'm going to push a little bit on some of what you said and ask you, when all is said and done, when the Mexican Congress has passed the law, what is politically feasible? What can we expect that the Mexican government will have in its hands and the industry and the sector will have in its hand, and how far they will not go? George?
I'd like to pasarla to
Alberto.
Alberto.
Well, you know, in terms of the political, I mean, to amend the Constitution, you need 2/3 of Congress and the majority of the states, which is 17 states. And we think that with the proposal of President Peña Nieto is very close to the PAN proposal. So between the two parties and the small parties, you know, that align to them, I think they will have the majority. They have been trying to reach consensus with the PRD because they don't want to have any political disruption. Even though the opening of the market is something that has to be done, and there is no mañana, and I think it's clear for everyone here and internationally, it's not that clear in Mexico. I mean, there is and yesterday we were having a dinner and George was mentioning something that there is a there is a different discourse here than in Mexico. So I think that will happen. The term of the Congress ends in December 15th. So hopefully this will happen. And then the next term for the Congress will be February 15 to April 15. And that's where we should expect that the underlying legislation be proposed to probably, if everything goes well, that the first structures of agreements by the end of next year or probably early 2015.
Thank you.
I would like to add that additionally what Alberto mentioned to you, one important legislation that should be also approved is the tax reform, because if we don't have a new tax regime, Pemex and the government won't be able to do what they want to do. So I think both reforms, the constitutional reform, Article 27 and 28, should be approved, and also, or besides that, the tax reform should be done as well. Thank you.
And tax reform was passed by the Senate.
I mean the tax reform for the exploration and production projects in Mexico.
Okay, thank you.
Yeah.
George, are you going to pass the?
Go ahead to the next
Okay.
question.
Thank you. Yeah, actually, it pushes a little bit on that issue of taxes, royalties, and fees for Pemex. Do you think that the fiscal reform, the tax hike that the Mexican government just approved, the Mexican Congress just approved this week, is enough to begin to reduce the companies or the government's dependence on the companies' revenues so that Pemex can begin to sort of be let go, or Mexico's dependence on oil revenue, which is kind of an initial requirement for this, be sufficient? Is this fiscal reform sufficient?
Well, I think that the point of the reform in the exploration and production activities is still pending. It has not been approved yet. So that was an issue that the current legislature or Congress have not approved. They will discuss it further in another meeting. So I think what we need is that this tax regime will benefit Pemex and also the companies in order to be competitive and to have more players involved in these activities in Mexico.
George?
I think it's important to keep a balanced discussion so that we don't get what I call too Pemex-centric. The challenge in front of the Mexican government is and the Mexican society in general, I think, is to say what kind of an oil sector do we want, not what kind of a Pemex do we want. And so I think the changes in the Constitution along the lines that you were saying, Alberto, and that we've all been saying are directed less to how to sort of change the mascara on Pemex than to saying let's open up a fresh window onto how to think about the oil sector in general.
And I think, just comment on what George said, I think that's right. I mean, the part of the problem is in Mexico, you know, the oil sector is Pemex, right? So that, but I think that's a very important distinction. And, you know, along this discussion, as, you know, I have been following it, you know, sometimes, particularly the opposition, they look too much to the past and, you know, how we got where we are and not where we should be. Right, so, and it's kind of sometimes it's hard to move. I mean, the history is very important to shape your future, but you really need to look this beyond your borders, because the issue that Mexico has in the energy sector now is not only an internal discussion among the three main parties, but it's the competitiveness of the country and international arena is at stake. And that's what we should, I think, be thinking about.
I have a question for you, George, to begin with. Your concept of Pemex 2.0. How realistic is the idea that Pemex will become a true international company, not a government agency, able to operate as an oil company, compete with others inside Mexico, and then also invest and compete with others outside Mexico?
Well, I think I've raised an important question that Froilan had touched about, and I think the lawyer should speak to, and that is, can Pemex, as an agency of the Mexican government, in fact, legally enter into strategic associations inside Mexico? And I don't know how Pemex might think about it. I don't know what the law might think about it, but I suspect that the oil companies would not welcome that idea for the reasons that I've said. And the second thought is Pemex 2.0, I say, is inevitable. But it's certainly not, it hasn't been raised, except by me, so far as I know, in the current discussion of energy reform in Mexico, nor will it be raised, I suppose, in the current round of discussion, but it is inevitable that it will be raised at some point in the future.
You know, just one comment there. I think I agree with everything George said, and I think it's critical that, you know, how Pemex is going to be shaped in this restructure. And as of today, is an decentralized entity, is an organismo descentralizado, is part of the government, is just like any other agency, like the trademark office in Mexico. And really, you know, I think, this is my personal view, that it will need to be reshaped more as a corporation owned by the government to be able to act and react more quickly in the market. One of the big issues is that the opposition has been challenging this reform as, you know, you are going to privatize Pemex and the energy sector. And really, you know, this idea to convert Pemex from a government agency to a real corporation, you know, will give a lot of trouble inside Mexico, particularly with the opposition. But I think one of the worst things that the government can do now is go through all these political issues to approve the reform and then have a reform that is not meaningful. And I think, you know, removing the
to participate with other companies, maintaining the state company Pemex as the holding company or as the owner, by creating probably companies besides Pemex that could participate or could join with the companies in Mexico or abroad. That means that, for example, in the case of the United States, Pemex should see to participate in projects here through an affiliate, the United States, and with approval of all authorities here, with the Bureau of Ocean and Environmental, the BOEM, and all that kind of stuff. I think there is no limitations on that. There are ways we have to analyze those ways to do that. But the idea is to maintain a government company that is the owner of the, well, no, the owner is the country, but through Pemex, Pemex has to maintain those hydrocarbons of those resources on the name of Mexico. Thank you.
George, let me go back to one point that you made about sovereign immunity. Under what mechanism can Pemex be held fully responsible under international law, and under what mechanisms can it actually claim sovereign immunity if it becomes Pemex affiliates abroad, register abroad, and then Pemex a government agency or a government-owned company? How would that regime look like?
Well, Javier and Alberto are better equipped to speak about that than I am, but in this article in Reforma, there was one mistranslation, or not exactly a mistranslation. They couldn't find the right term in Spanish to capture the idea. And that term was, I said Pemex 2.0 had to have an arm's length relationship to the government. So all of you Spanish speakers, quickly tell me how to translate arm's length relationship into Spanish.
Arm's length.
Arm's length.
Sana distancia. Okay, good. Healthy distance. All right. So they didn't think about that, and I didn't think about that. But to have a healthy distance, then that company with this healthy distance would be able to be fully responsive to any kind of a Macondo obligation. But as a federal agency, there's always the option to say, look, this was an act of sovereign, as it was in the Ishtak 1, they said this is an act of a sovereign evaluation of the petroleum resources of the nation. It was not a commercial act. And so therefore, since it wasn't a commercial act, we're not responsible for commercial consequences. So that's where I think having a Pemex 2.0 with the sana distancia would be a great step forward in the ways both of you suggest.
I mean, I think, you create a subsidiary that is a corporation, obviously, can participate in the commercial arena as any other player. I think the issue goes to the decision-making process and how the company will operate from the top. And as George mentioned and my colleagues mentioned here, I think, the new Pemex will have to be removed as far as possible from the political arena and operate more like any other company, where decisions are made based on business judgment and not on political agendas. It's interesting, for example, in the board of directors of Pemex has, I think, 15 members, and 4 members are appointed by the union. This is a historical issue because, as you know, the Pemex was, the sector was privatized because of a labor dispute. And it's interesting that the PAN proposal and the PRD proposal, the left wing, they are proposing to remove that, to improve corporate governance. So I think they can reach some consensus, and one thing I would like just to point is that the government has done an extraordinary work on getting consensus in this reform. In the context of Pacto por México, the Mexican Pact, where before putting all these reforms in Congress, they sat with the parties, the 3 main parties, and kind of have an agenda that, where just basic agreements that there will be an energy reform. They didn't discuss the specifics. There will be a tax reform and so forth. And I think this government has built consensus that honestly we have not seen, in many years in Mexico.
Mm-hmm.
I agree with both, with George and with Alberto, regarding that Pemex should be only an operator, not involved in any political decisions. Those political decisions should be maintained by the Ministry of Energy or the authorities below, that ministry, the president. Pemex should operate in that way. Because right now there are a lot of political issues involved, so we should leave that outside and try to be more efficient in that way.
George?
I wanted to just add one 4th reason why Pemex 2.0 is important, and that is the importance of the minority shareholders who own common stock. Imagine this company with Pemex 2.0 that's 70% owned by Pemex as the holding company, and then 30% owned by, Carlos Slim and everybody in this room. And the important thing is that when Pemex makes a decision tomorrow, the stock goes up or down. And today, the Mexican government and Pemex is operating in the dark. In a terrible darkness as to what the right policy is, what the right decisions are, what the right personnel decisions are. And so to have somebody, even in a minority position, who's not going to change your mind necessarily, but to say, I'm voting your shares up or I'm voting your shares down tomorrow. And that would be a great sobering dimension into all thinking about energy policy in Mexico. If you had that kind of responsiveness from a minority shareholders to give you some real world validation as to the sanity and as to the wisdom of your decisions.
And just let me add something, I love the idea, George is throwing, because one of the big discussions in Mexico is, the oil is for Mexicans, right? I mean, Mexicans should own the oil. And which a better way to own the oil that have a share participation in the oil state company of the country? I mean, there is no more direct way, because, when I hear all these discussions, and I go and pump gas in my car, well, I'm in Mexico, and it's like, well, the oil I'm Mexican. I live here, but I'm Mexican. And it's like, it doesn't mean anything to me. I pay this, it doesn't mean anything to me. But if I have a share of the state-owned company, it has a lot of meaning, because, I get involved in how the company is doing.
Thank you. We have about 10 to 15 minutes to open it up for questions. I'm sure you got plenty of them. Dylan McNally has the microphone over here. Dylan. Please get the microphone very close to your mouth so that the video, this is streaming live, and also we'll post the video on the website, so we want to capture your voice.
Okay. Stephen Zamora, University of Houston. Excellent discussion, everyone. And just one comment on sovereign immunity and then a question. It's generally accepted under international law now that an absolute notion of sovereign immunity as an absolute matter is not the rule of international law. Sovereign immunity, as applied or as understood by US courts, involves a more limited nature and applicable to, let's say, Pemex or any government-owned entity in the future. George has already mentioned that the commercial activities exception is applicable. The Eekstock case is a very rare case. It was a district court opinion that, as far as I know, was never endorsed by a court of appeals, certainly not by the Supreme Court, in terms of what kind of well was being drilled, so that if a government-owned entity is involved in a commercial activity, then it is not deemed to be immune from the courts. More importantly, a government entity can waive immunity. I've never seen an international loan agreement that did not involve waiver of immunity by government agencies, and that would be obviously something to do in terms of any commercial venture. My question has to do with the fact that until 5 years ago, Pemex was an unregulated, decentralized government entity. 5 years ago, Congress created the Comisión Nacional de Hidrocarburos to regulate upstream oil and gas activities in Mexico 5 years ago. The commission now has 60 employees, including secretaries and everyone. 60 employees to regulate the entire upstream oil and gas industry. I don't think that's, let's say, adequate. My question is, if Mexico changes and adopts a competitive energy industry, does Congress and does the Peña Nieto administration understand that it's going to have to invest in regulation? Or is there a tea party in Mexico that says you don't need it?
Thank you. That's a very good question. And Javier, it looks like it's asked for you.
Well, I will try to answer your question, Steve. I think the Comisión Nacional de Hidrocarburos, as you mentioned, is right now with no budget, no personnel, well, or not sufficient budget or not sufficient personnel to do all the regulation that they should do. But I think with the reform, they are trying to state a trust for all the revenues of the sales of the oil. So in that trust, I think it's my impression that it's provided a percentage to be given to this Comisión Reguladora de Energía and also to the Ministry of Energy in order to give all the support to them for drafting the contracts, for taking care of all the activities of the country, and to be a more regulator instead of being only a policymaker and not to try to be involved in all the EMP projects. So there is provided in that regulation that there will be a percentage to those authorities.
And I think, you know, also the other issue is, you know, there will have to be the right allocation of authority between the three regulators, you know, the Ministry of Energy, the Hydrocarbons Commission, and the CRE, you know, the Energy Commission. And I think, you know, I don't know if the idea is to create some sort of Hydrocarbons Commission reloaded, or just a separate entity that we can, you know, have more staff and more resources to, you know, participate in giving the contracts and all that kind of stuff. But the allocation of authority will be very important. And then the other issue is that, there will be required a lot of regulations, right, in the new regime. But the government and the Congress, they will have to be careful not to over-regulate the sector. And that will be a fine balance between, starting a new market field with the rules and then keep them, at minimum just to make it work, well.
George?
It's important to keep in mind that the Hydrocarbons Commission is an advisory body to the Energy Ministry. It's not fully set up as an independent regulator. Secondly, the mandate of the Hydrocarbons Commission has only been to regulate or to advise on regulate and to provide public oversight. I think that's the best way to think about what the Hydrocarbon Commission is doing, providing at least token public oversight of Pemex. Now, the Hydrocarbons Commission has gotten into a conflict or an argument with Pemex on lots of issues, but one of them has to do with the other companies that are working in Mexico, like Petrofac and like Schlumberger and Halliburton, that have these, and Diavas, that have these new incentive contracts. And the position of the Hydrocarbons Commission, and I've heard Juan Carlos Cepeda speak in Houston and speak elsewhere about that, is look, the companies that work in that work in Mexico under contract with Pemex are indirectly under our regulations. But so far as I know, there's no such thing as indirect regulation. You're either regulated or you're not. And so, in fact, we have a hole, you might say, in the system in which you have companies like Petrofac and these others that are not regulated by the Hydrocarbon Commission. Because Pemex has never agreed to that. Pemex has said, look, you regulate us, we regulate or supervise the contractors that have incentive contracts with us. However, these contractors are producing oil from the national patrimony and they need public oversight. So there's an issue there that needs to be untangled in any rethinking about the Hydrocarbons Commission and the role of public oversight.
Great, thank you. I saw another hand.
Yeah.
There's a hand, yeah, over here and then in front, yeah.
Please try to keep your questions brief. We only have about 6 minutes left.
Thank you, Tony. I'm Pablo Medina from Wood Mackenzie. My question was mostly to Javier. It was about the chosen upstream fiscal regime. So far as it seems, given that it will be a royalty, then it will be a profit split, let's say, from operation margins, and then you'll have a corporate income tax. That sounds like a Peruvian, like the old Peruvian PSC, with a key difference that hydrocarbons are delivered at the wellhead to a government entity. The only thing is about operational margins, we're taking costs into account. Most PSCs have a cost limit. Have you heard anything about having an explicit cost limit, or will it be more of in the deduction side?
Thank you.
Well, I think what I say is I'm not a tax expert, but what this law says, the hydrocarbon revenues law, is that these taxes will be paid after you deduct all the costs involved in the operation. So there is no limit in those costs, as is drafted this law.
Anybody else? Right here in front and then back there.
Thank you. Carlos Garcia, Luz Energy Group. I'd like first quick comment to Alberto. You made a mention in your presentation about the importance of the energy reform, and I would reiterate, and I think that a lot of people, to really understand the importance of the reform and what we're asking, what the Mexican government is asking the country to absorb, is really almost synonymous to changing people's perceptions of the importance of the Boston Tea Party and Paul Revere's ride. I mean, it really is talking about the sovereignty. In Mexico, we've been hearing about the petroleum industry, and then by default, Pemex being the guarantee of the sovereignty of the country. So it's critically important. I'd like to just ask your impressions about the timing of this. You did mention the energy reform, the broad-based energy reform, possibly by the end of the year, but really the devil's in the details, really in the secondary laws, and in the regulations to come, which I think, you know, from your comments, there's a lot of work to be done as a potential private investor in Mexico. What are your impressions about timing? What do you think we would be looking at?
Well, I think the underlying regulations probably will be discussed in the next term of the Congress that starts, I think, February 15 to April 15. And that's where hopefully they will, you know, come up with the specifics. And then, you know, I think they will need time to restructure whether there is a new hydrocarbons commission, kind of reloaded, or, you know, all these funds and everything probably will take the first 6, 7, 8 months, I guess. And this is all guessing, to land the specifics of contracts and authorizations probably by the end of next year or probably early 2015.
Anybody else like to comment on that?
I want to add that, for example, in the tax reform for revenues, that it's supposed to become effective on January 2015. So I think the next year will be the term for the secondary laws to be drafted or to be approved by Congress. That's our hope.
We'll have another conference on that. George, any observations? Another question, and anybody else that I can see? Hands? Go ahead.
Hi, Alex Bruton. I'm an interested party. My question goes kind of to what George was talking about this darkness that seems to be kind of prevalent in Pemex. And my question is, what learnings do other countries and other Latin American countries, in Brazil, for example, and Petrobras, et cetera, what learnings can Pemex take from Petrobras' experience and how they have been able to invest and create investment in Mexico or in Brazil, and is it relevant to the Mexican case?
Thank you. Javier, you tackle that?
Well, the Brazilians have set up a real regulator. The Brazilian oil regulator is not an advisor to the energy ministry, is an independent, autonomous powerhouse. And so that's one lesson right there. And the second lesson is in having a minority of shares in the stock market. The Petrobras' shares have gone down 25%, I was told, in the last few years. Why? Because it's been 6 years since they had a public offering of a tender. They've changed the national content rules. They've restricted, put on layer and layer of new restrictions, and the minority shareholders don't like it. And so that's a lesson for Mexico. You know, hey, do you like it or you don't? Oh, you don't? Well, maybe I'll change it or maybe I won't, but at least I'll know what you think about it.
Mm-hmm. Yeah. And also I think that one of the targets of this reform is to create a new oil industry in Mexico with the participation of more companies. Not only Pemex, but also Mexican companies, service companies, and a lot of people could be involved in this project. So that's the idea. In the same way as Brazil created a national industry. Mexico doesn't have a national industry for oil and gas projects. So one of the intentions is to create this industry in Mexico.
I just want quick comment, and I think, you know, that has been the tendency to try to emulate what, you know, other places are doing. But Mexico features are unique in the sense that, you know, one of the reasons I think the government has been able to move this agenda forward is that Pemex is not going to be privatized. And, you know, there is a very strong feeling about that. You know, the nationalization of Mexico was caused, as you may know, because, you know, the oil companies didn't want to honor a ruling by the labor authorities, by the court, that they had to pay some indemnifications to the workers. And they said, we're not going to comply with that. And that's when the government went and nationalized the assets. So you know, we need, you know, in terms of bringing other structures, I think is a great idea, but will always be shaped by our unique political situation. Particularly, you know, we are just right next to the States, right, which is different.
Thank you. we'll take one more question in about 2 minutes, and then we'll take a 5-minute break and come back to the second panel at 10 sharp. Yeah.
Sure. Thanks. Larry Pascal with Haynes & Boone, and just building on the comment that was made there and talking about the other regional examples. The other thing that they have in common is that they had an independent regulator responsible for putting out to bid the various fields, and each of the national oil companies was competing on an independent, transparent basis in public bids for those fields and those opportunities. As Alberto said, Mexico is probably not there, but that is really the best way to inspire market confidence, basically, of a transparent segment that national oil companies from other countries and majors and independent oil companies can participate in.
Comments? Great. Well, it's 9:56. We have 4 minutes. Take a break and then come back for the next panel at 10 a.m. Thank you. Thank you, everybody.